ఓకే సార్, వాళ్ళు మిగతా వాళ్ళు ఒక ఇద్దరు ముగ్గురు జాయిన్ అయినప్పుడు చూసి మీరు స్టార్ట్ చేసేసి.
ఓకే సార్,
థ్యాంక్ యూ.
Okay, within 2 minutes I will start. Okay, I'm starting the class. Let them join later also. This is a recorded video, no? So they will listen later also. Yeah. Today is anyway, today is the last class. So last class of this academic session of my papers especially. So basically this last session I am discussing that the enforcement of the TRIPS agreement, and the second one is patent in new areas. So what is this enforcement under TRIPS agreement? We have to do what this enforcement under TRIPS agreement. Basically due to these legislations and effective administration infrastructures, what they done is in the case of acquisition of intellectual property rights, so lot of steps towards the intellectual property protection is they are having the legislations enacted, the enforcement of protection also. But the acquisition of intellectual property, because of the little economic value, so these rights cannot be enforced effectively. So the credibility of the intellectual property system depends on the enforceability of the intellectual property rights. So the agreement on TRIPS, trade-related aspects of intellectual property rights, this forms a part of overall agreement establishing the World Trade Organization. It requires the members of the World Trade Organization to ensure that effective enforcement procedures are available. So the TRIPS agreement also includes provisions requiring action by custom authorities against the suspected counterfeiting and pirated goods. So what is the need? What are the international obligations for enforcing the intellectual property rights? So the first one is the intellectual property right holders, they are not able to effectively enforce their intellectual property rights. So due to the ineffectiveness of the right holders, so IP rights in various countries around the world requires these international obligations. Number second one, so they were facing inadequate procedures for obtaining and preserving or the presenting the evidences also. And another obligation is they were facing inordinate delays in bringing a case to trial and obtaining a final judgment also. Another one is they were unable to obtain with difficulty preliminary injunctions, at the same time seizing orders or immediate relief, legal reliefs also. So their damages awards and criminal sanctions were not adequate in the case of any infringement happen. At the same time, the proper enactment mechanism was not available at the borders to prevent the importation of the infringing goods. So because of these international obligations, the enforcement of intellectual property needs arises. So the enforcement provisions of the TRIPS agreement, they set forth in some details the procedures and the remedies that each member must make available in its domestic law to enable right holders to enforce intellectual property rights covered by the TRIPS agreement. So what are the remedies available against the infringement? So as we already see that in the case of enforcement, what the remedies available, that is civil remedies, administrative remedies and criminal remedies. So what are the civil and administrative procedure and remedies available under the TRIPS agreement? So all the members of the TRIPS shall make available to right holders civil judicial procedures for the enforcement of the intellectual property rights. So there should be a fair and equitable procedure for all parties. What should be the fair and equitable procedure? So fair and equitable procedure, it includes the defendants shall be given timely and detailed written notice of the basis of the claims. Second one, the parties shall be allowed to be represented by the independent legal counsel. And third one is procedures shall not impose overly burdensome requirements for mandatory personal appearances. And fourth one, all parties should be allowed to substantiate their claims and present all relevant evidences. The fifth point, which includes fair and equitable procedure, is there should be a way to identify and protect confidential information unless contrary constitutional requirements. So these are the this procedure is involved in the fair and equitable procedure. And another one is the judicial authorities shall have the authority to order parties to produce a relevant evidence. So they have the authority to make preliminary and final determinations against a party who, without good reason, refuses to provide evidence. So the judicial authorities shall have authority to order a party to desist from an infringement also. That means they can issue temporary restraining orders and injunction orders also. At the same time, where the infringer had a reasonable grounds to know that why he is engaged in the infringing activity, then the judicial authorities also ordered the infringer to pay adequate damages to compensate for the injury, which may include attorney's fees of the right holder also. That means if the infringer may say something that why he is infringed, in that case also the judicial authorities has right to ordered to pay the adequate damages for the compensation. And another one, the members may provide that the judicial authorities shall have the authority to order the infringer to inform the right holder of the identity of third persons involved in the production and distribution of the infringing goods or services and their channels of distribution. So the judicial authorities may order preliminary injunctions and ex parte seizure, where delays damages a demonstrable risk of evidence destroy. So if the risk evidence destroy is demonstrated, then the judicial authorities also ask the ex parte seizure also. So all the members of the TRIPS agreement shall only exempt both public authorities and officials from liability to appropriate remedial measures where actions are taken are intended in good faith in the course of administration of that law. Then only, so these are mentioned in the TRIPS agreement. Some special requirements related to the broader measures. So TRIPS, it also TRIPS agreement defined certain terms. So what do you mean by counterfeit trademark goods? So according to TRIPS agreement, the counterfeit trademark goods shall mean any goods including packing, bearing without authorization a trademark which is identical to the trademark validly registered in respect of such goods or which cannot be distinguished in its essential aspects from such trademark and which thereby infringes the rights of the owner of the trademark in question under the law of the country of importation. So this definition was given by the TRIPS agreement. At the same time, TRIPS agreement also defines the pirated copyright goods also. So the pirated copyright goods, that means any goods which are copied, made without the consent of the right holder or person duly authorized by the right holder in the country of production and which are made directly or indirectly from an article where the making of that copy would have constituted an infringement of a copyright or a related right under the law of country of importation. So basically the counterfeit trademark goods and pirated copyright goods So counterpart trademark goods. So for example, Adidas we are discussing. So Nike. So the changing the name or changing the name style pattern in this in spite of labeling Nike, they may label as a Mike also. So that is the counterfeit trademarks. But in the pirated trademarks, pirated copyright goods, especially if you are some movies are releasing. So in that movie, even though they release, so the content should be copied in a DVD and spread over that. That is called pirated copyright goods. So with regarding to this enforcement, what are the criminal procedure? So the criminal procedure, what are the criminal remedies? So the criminal procedures and the penalties so will be applied at least in case of willful trademark counterfeiting or copyright piracy on a commercial scale. So before that, the civil and administrative remedies, it is very minimal. In the case of civil and administrative remedy, in the case of civil and administrative remedy, what they will get is they will get award damages, okay, or confiscation of goods like that. Petty offences will be given. But in the case of criminal procedure, that means where the infringer he willfully trademark counterfeiting has done or willfully copyright piracy is done on a commercial scale, then the criminal procedure applies the penalties also. So the remedies available under the criminal procedure code is imprisonment, monetary fines, or imprisonment along with the monetary fines if it is sufficient to provide a deterrent. So it should be consistent with the level of penalties applied for crimes of a corresponding gravity. So these are the criminal remedies available under civil, criminal, and administration. So there is a institutions who are effectively working under the enforcement of the intellectual property rights. So due to the increase or due to the advancement of technology, it led to the intellectual property crimes very fast. So the pirating and counterfeiting have been increased so in a global market. So due to this, the government, business, society, and consumers are losing lot of money, billions of dollars. So the crime has been flourishing because of high returns and a low risk and less penalty. So in this area, the custom and police play a crucial role while combating the protection of intellectual properties or fighting against the intellectual property crimes. So what is the role of customs? There is one body called role of World Custom Organization. So this World Custom Organization, hello. So this World Custom Organization, which was established in 1952. So this World Custom Organization was established in 1952. It is an independent intergovernmental body. So it is an independent intergovernmental body. It is an independent intergovernmental body with responsibility for dealing with the custom issues. So the aim of this World Custom Organization is that it enhancing the effectiveness and efficiency of custom administrations, and it also assists in the custom to the intellectual property holders. At the same time, how to contribute to the national development goals, particularly in the area of trade facilitation, revenue collection, community protection. So in these all situations, they are helping. So the customs role in enforcement of intellectual property, right? Basically, it has been highlighted by the World Custom Organization. Number one is they're facilitating international trade at the same time by protecting the border. Second, they're planning at the international level against transnational organized crime. And they're also assist in the enforcement of TRIPS agreement. The World Customs Organization, this intellectual property rights model, they have prepared a model legislation. So this model legislation, it has been developed to help countries in drafting or revising their existing custom legislations. So in 2003, the World Custom Organization Enforce Committee adopted the new model law on border measures. So this document is not binding upon the members, but it goes beyond the minimum standards required in the TRIPS agreement. So it represents best practices in the area of intellectual property rights for the customs, and also useful aid to the administration while they are drafting or revising their existing legislations. So what is the role of Indian customs in the protecting of intellectual property rights? So the Custom Act of India 1962, later amended by the Financial Bill 2005, it contains the measures for combating illegal import and export of goods, including protection of patents, trademarks, and copyright. So, according to this act, if the central government is satisfied, okay, according to this act, if the central government is satisfied that it is necessary so to do for any purposes specified, including the protection of patents, trademark, or copyrights, so it may be notification in the official gazette, prohibit either absolutely or subjected to such conditions. So the Trademarks Act prevents the owner of a trademark claiming infringement in respect of a product. Then he has to produce along with attach a trademark where he has expressly consented to the use of the trademark. And also the Foreign Trade Development and Regulation Act 1992 of India, it also stated if imported goods do not conform with the standards of weights and measures, packaged commodities rules 1977, then the Foreign Trade Development and Regulation Act 1992, according to that act, the custom officials, they are prohibited these goods. Such goods can be stopped by the custom authorities from being imported. So another body to protect the intellectual property is role of police. So in the global sense, Interpol, it is the world's preeminent police organization. Their endeavors to protect, detect, and suppress the crimes. So the Interpol has created a multi-agency working group. It is also called as Interpol Intellectual Property Crime Action Group, IAPCAG. Basically, this group has representatives from police, custom officers, and intergovernmental organizations, and even private sector association also. They are adding the persons. The group works as a forum for coordinating and enhancing international action against intellectual property crime. The Interpol recommended the best practices and the successful models for investigating IP crimes nationally, because in the domestic also they have to investigate in the domestic policies. So the Interpol recommends good practices also. So the basic objective of this Interpol Intellectual Property Crime Action Group was the objectives. First one, to facilitate international law enforcement action against intellectual property crime. Second one, they has to raise awareness of the economic and the social impact of the trade in counterfeit products and pirated goods. And the third, they create intellectual property crime investigation training programs, and also they improve the coordination of intellectual property right matters among police, customs, and private sector also. This is the role of police in the global level. And what is the role of police, Indian police? So according to the Trademark Act, section 115, especially, it authorizes the police officers not to below the rank of deputy superintendent of police and being satisfied to search and seize the infringing goods. So what this section 115 talks is, any police officer not below the rank of deputy superintendent of police equivalent may, if he is satisfied that any of the offences referred to in this act has been in doing or is likely to be committed, search and seize without warrant the goods, a block, machine, plate, other instruments or things involved in the committing the offence wherever found, and all the articles so seized shall as soon as practicable be produced before a judicial magistrate of the first class or metropolitan magistrate, as the case may be. So what this section talks about is, so not below the rank of deputy superintendent of police, he can ask the search and seizure without the warrant the goods also. So they have to produce judicial magistrate of the first class. This provided that the police officer, before making any search and seizure, he shall obtain the opinion of the registrar on facts involved in the offence relating to the trademark, and this shall be abide by the opinion so obtained. If the registrar says no infringement happened, then the police officer has to comply with the opinion. He has to abide with the opinion obtained from the registrar. At the same time, Copyright Act also mentioned the role of police. So according to the Copyright Act, any police officer not below the rank of sub-inspector may, if he satisfied that an offence under this act in respect of the infringement of copyright in any work has been, is being, or is likely to be committed, then seize without the warrant all the copies of the work also. So this also gives same powers to the sub-inspector. So this is the role of Customs Office, Indian Customs Officers, what is the role? Next, Police, what is the role? Next, Indian Police, the role. The settlement of disputes with regarding to this intellectual property rights. So even though the TRIPS also having the same settlement of dispute mechanism, that first they have to obtain civil, criminal, administrative procedures, but at the same time, due to this growth of this arbitration, conciliation, mediation, so there also follows the ADR procedure also. The same ADR procedure they are also following. There is a one specific concern here is that there is a domain name, internet domain name dispute resolution was passed by the World Intellectual Property Organization. So what is this domain name dispute resolution? Basically, growing popularity and the commercial application of the internet domain names, they have too much conflict with the trademarks and other intellectual property rights. So, in December 1999, the World Intellectual Property Organization Arbitration and Mediation Center, so they first provide a dispute resolution service under the Uniform Domain Name Dispute Resolution Policy. So this Uniform Dispute Resolution, Uniform Domain Name Dispute Resolution Policy, this was adopted by the Internet Corporation for Assigned Names and Numbers, ICANN, on the basis of recommendations made by the World Intellectual Property Organization in the report of the first World Intellectual Property Organization Internet Domain Name Process. So, this Uniform Domain Name Dispute Resolution Policy applies to registrations in generic top-level domains, .coms, .nets, and .org, etc. also. But the UDRP, the Uniform Domain Name Dispute Resolution Policy, allows a domain name registrant that loses in the administrative proceedings to challenge the panel's decision by filing a lawsuit also. So, this Uniform Domain Name Dispute Resolution Policy, it is limited to cases of registration and the use in bad faith. So for a complaint to succeed, the complainant must establish 3 cumulative criteria. Number 1 is the domain name is identical or confusing, similar to a trademark or service mark in which the complainant has rights. The second one, the registrar of the domain, the registrar of the domain name has no rights or legitimate interest in respect of the domain name. And also, the domain name has been registered and is being used in bad faith. If the complainant established these cumulative criteria, then only he will succeed. So under the Uniform Domain Name Dispute Resolution Policy, the respondent has 20 days to file a response from the date of the World Intellectual Property Organization Center notification. So this World Intellectual Property Organization Center, they appointed an independent 1-member or 3-member panel to decide the case. So the decision was taken 2 weeks by the panel once they established. If the panel orders the transfer or cancellation of the domain name, then the registry is obligated to implement the decision, except if he files any appeal. Otherwise, the decision of the panel is final here. So this is the WIPO Internet Domain Name Dispute Resolution. And the next concept is, it talks about patent in new areas. Patent in new areas, navigating new frontiers in patent law. The significant growth, especially after the focusing of Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, World Intellectual Property Organization. So it highlights the emerging challenges and controversies in relative to new areas of patenting, such as biotechnology, genetic resource, software, okay, reflecting the need for the robust legal framework to address these modern innovations. So first one is biotechnology. So biotechnology is one of the most recent topic. We are in current topic updating because there are many dimensions having that topic. So one is ethical issue of this biotechnology is an issue. So many of the biopharmaceuticals of the patent applications are using the genetic resources from the biodiversity rich countries and are processed in the developed countries. So what is the ethical issues with regarding to this use of biotechnology? So ethical concerns, the ethical dilemma surrounding the patenting of life forms, it raises questions about the ownership of naturally occurring organism and the implication of granting exclusive rights over them. There is a challenge in patentability criteria also. So due to this biotechnology, traditional views, especially regarding whether the isolation of microorganism or modifying a life form, this qualifies for patent rights. So when these entities exist in nature, so it is subjected to the what should be the criteria to give the patentability. So what is the intersection of biotechnology and intellectual property right? Rapid growth of biotechnology industry that led to the commercial exploitation of biotechnology innovations. So this commercial exploitation, this has triggered the efforts of industries to fit in organic subject matters like natural extracts, modified life forms, derived substances into the intellectual property right regime. There are two main issues of controversy arising. Number one is whether the life forms may be given patent protection, and by doing so, should a distinction between lower and higher life forms be made? Then it should be condition of novelty, inventory step is diluted in order to get such patents. The second one is the wider issue under discussion, however, is about the ownership of these resources. So these two are the leading questions, issues or controversies with regarding to the biotechnology and intellectual property rights. So with regarding to granting a patent, invention is necessary. So what is the invention? So what qualifies the invention? So the invention means not mere discovery of the already existing things. In biotechnology, patenting, it would be intersecting to have a close look at the meaning of invention as interpreted in different industrial property. Now, according to the Paris Convention, what the invention is, it does not expressly spell out the definition of the invention, or even for the matter, the panel patentable subject matters also. But Article 1, Clause 3, it specifies the broad scope of industrial property. So that Article 1, Clause 3 states that the industrial property not only applies to industry and commerce, but also applies to agricultural and extractive industries and to all manufactured or natural products. Example, wine, grain, tobacco leaf, fruits, cattle, minerals. These are all comes under this. So the TRIPS agreement, something go beyond the Paris Convention, it spelled out the definition of the patentable subjects. According to Article 27, it states that excluding the matters listed in Article 27, Clause 2 and 3, the patents shall be available for any invention, whether products or process, in all fields of technology. They provided that they are new, involve inventive step and are capable of industrial application also. But this biotechnology field, a landmark decision was made by the US Supreme Court in the Diamond versus Chakravarti case in 1980. So in this case, the court ordered that the patentable subject matter could include anything under the sun that is made by man. So in this case, the Supreme Court rejected the argument that an engineered bacterium or being a life form was not a patentable. So what is the criteria for patentability? So basically, for the criteria of patentability, usually 3 conditions are there we have to fulfill. Number 1 is novelty. Number 2 is inventive step, also known as non-obviousness. And third is industrial application or usefulness. So what is novelty? So novelty means a patent is granted only for truly new inventions, because it preventing individuals or entries from monopolizing ideas already available in the public. So this condition protects the fundamental principles of innovation and encourages further advancements in technology. So what is the inventive step? So inventive step, it refers to the requirement that the invention must not be obvious to someone skilled in the relevant field. So this criteria is crucial in distinguishing between mere discoveries and genuine inventions that contribute to the advancement of knowledge and technology. And the third one is industrial application. It is also called practical utility. So in the industrial application, it means that the invention must have a practical use in some industry. So this condition, it ensures the patents are granted only for inventions that can lead to the tangible benefits So thereby, they're promoting economic growth and technological progress. So what are the ethical concerns surrounding this um, biotechnological patents? So the ethical concerns were the central issue in the biotechnological patenting revolves around the ethical implications of this practical patenting life forms. So this question rises whether it is justifiable for an individual to hold exclusive rights over a living organism, or various nations have responded differently to this ethical dilemma. Basically, this means every member state is given free choice to apply the exclusion from patentability for such subject matters that may prejudice morality in their territoriality. That means, obviously, some countries may stop to give patent on particular things which may against to their morality according to their territory. So basically, this criteria does not exist in the American system. Even in other countries, they use this criteria. It becomes significant only after the trend of patenting life forms started. The beginning was with regarding to that patenting of a transgenic animals. Initially, what happened that the America granted US Patent Office granted a patent to the in 1988 concerning the transgenic mouse. Okay, that time it is very controversial due to the a rise of very strong emotional reaction in the United States. So the Supreme Court also applied the Diamond versus Chakravarti case here concerning a genetically modified bacteria used for the degradation of hydrocarbons. So this is the ethical concern with regarding to this biotechnology patentability. So what are the defenses available in patent law? Especially Article 30. Article 30 of the TRIPS agreement, it provides the exemptions to patent rights conferred. So this Article 30, it exempts three parties, that is innocent bystanders, farmer rights, and experimental defenses. These used as a defenses under Article 30 of the TRIPS agreement. So protection to innocent buyers. So in the case of biotechnology inventions, it involves subject matters which have ability to reproduce themselves, unlike the mechanical inventions. So due to this, even after taking due care of protecting the invention in a restricted area, it is possible that some patented life form are exactly or similar one is produced at some other place also. For example, there may be a variety of plants which may be genetically modified and duly patented. It is possible in nature that similar kind of mutation in the gene can also occur accidentally. So in that case, such mutant variety would exhibit same characteristics also as the patented one. So now, in such case, the innocent grower of such mutant variety should not be held responsible for patent infringement. And the second one is farmers' rights. So for centuries, farmers have been cultivating various plant varieties, and their efforts in selecting and promoting the best breed have made it possible to achieve today's quality products. So, all farmers have been growing the harvest in their fields and using it for consumption after saving the best seeds for the next plantation. So, this practice should be allowed to continue even in the patenting era. So, the farmer rights are crucial in the context of biotechnology because it granting the farmers the ability to save, use, exchange, sell the seeds. So this defense recognizes the contribution of farmers in agriculture innovation and biodiversity conservation. The third defense is experimental defense. So this defense is to achieve a broader goal of patenting because the experimental defense it provides in patent law which allows researcher to use patented materials for experimentation and research purposes without infringing the patent rights. They foster the innovation and scientific advancement. So there is another new area which should be concerned that genetic resources. In recent days, there is some tensions between the national sovereignty and the way in which plant genetic resources are spread and utilized. For example, consider a country such as Ethiopia that has historically been thought of the home of the coffee plant. But Ethiopia has not saved in the economic benefit that has been a result of coffee's spread over the world. There are many other such examples also there. So all of these plants, they provide world with the products that are benefit to all the mankind. So should the world compensate the people who are responsible for domesticating or discovering the beneficial properties? How should this be done? So to overcome this, three conventions are related to these genetic resources. Number first one is CBD, Convention on Biological Diversity. Second one is International Undertaking, IU, on plant genetic resources for food and agriculture. Third one is International Treaty on plant genetic resources for food and agriculture. The Convention on Biological Diversity. So this Convention on Biological Diversity came into force in 1993. So the CBD, Convention of Biological Diversity, has adopted to address the conservation of the biological diversity. Basically, it has three main objectives to establish the Convention of Biological Diversity. Number one is the conservation of biological diversity. The second one is sustainable use of its components. And the third one is fair and equitable sharing of the benefits arising out of the utilization of genetic resources. So the equitable sharing can be achieved by access to genetic resources and by transfer of relevant technologies only. So this Convention of Biological Diversity emphasizes the sovereign rights over nation, their natural resources, and promotes access and benefit sharing mechanisms. The second convention is International Undertaking on Plant Genetic Resources for Food and Agriculture. This is the first comprehensive international agreement dealing with the plant genetic resources on food and agriculture. It was adopted by the Food and Agriculture Organization, FAO, in 1983. This international undertaking was adopted to promote international harmony in matters regarding access to plant genetic resources for food and agriculture. So, in all the countries, the international undertaking, it seeks to ensure plant genetic resources of economic and social interest, particularly for agriculture, which will be explored, preserved, evaluated, and made available for plant breeding and scientific purposes. So the international undertaking, monitored by the Commission on Genetic Resources for Food and Agriculture. Basically, this international undertaking, they passed 3 resolutions. Number 1 is the first resolution. It recognized the plant breeders' rights. The second resolution, it recognized farmers' rights. The third resolution recognizes sovereign rights of nations over their genetic resources. And one significant point is that this international undertaking on plant genetic resources for food and agriculture is a non-binding agreement. So, to make bind, another resolution also passed, instrument is also passed, that is international treaty. This international treaty on plant genetic resources for food and agriculture. So this also adopted by the Food and Agriculture Organization only. This was adopted in 2001. This was adopted because the international undertaking is a non-binding agreement. So to make bind, international treaty was established. The international treaty is a legally binding treaty and it covers all plant genetic resources relevant for food and agriculture. So the objective of the treaty, 2 objectives. Number 1 is the conservation and sustainable use of plant genetic resources for food and agriculture. And the second one is fair and equitable sharing of benefits derived from their use in harmony with the convention of biological diversity for sustainable agriculture and food security. So the treaty also provides for sharing the benefits of using the plant genetic resources for food and agriculture through information exchange, access to and the transfer of technology and capacity building. So these are the 3 institutions with regarding to deal with this genetic plant and genetic resources. So what are some national efforts in preserving the genetic resource protection? especially India, the India passed Indian Biological Diversity Acts in 2002. So this Convention of Biological Diversity was established in 1992. So based on that, we enacted the Biological Diversity Act. So the nations are actively adopting their patent legislations to better safeguard the genetic resources. It ensures equitable access and benefit sharing. So the next concept with regarding to this protection is new areas, patent in new areas is software, computer software. So we know that we are under the middle of the information revolution.
What are you doing, man?
As we navigate the so-called information revolution, the software stands at the forefront by driving innovation and efficiency across various sectors. So, by protecting software from unauthorized copying and use is not just essential for safeguarding intellectual property rights, but also for maintaining the economic viability of software development. So, without adequate protection, the developers face significant challenges in recouping their investments, which could stifle technological advancement and creativity in the software industry. So, in the software industry, the main concern is with regarding to protection of computer software under the copyright. During the 1980s, intensive international discussions regarding the protection of computer software took place because they aim at resolving the question of whether such protection should be under copyright or patent law. For example, if you take any chip, memory card, initially in 1980s, they decided that that chip, entire chip, whether it comes under the definition of protection of copyright or protection of patent, because the chip which was manufactured design that comes under the patent, but the software, the matter which you used in that the software, that is comes under the copyright. So this type of questions arose in 1980s. So a committee of experts through the World Intellectual Property Organization and this UNESCO, they marked a decisive breakthrough in the choice of copyright as the appropriate form of protection of the computer programs. So the main reason for choosing copyright protection with regarding to the computer software is the computer programs are basically writings, and under the Berne Convention of the purpose for which writings are created is irrelevant from the viewpoint of their qualifying as literary works. So, accordingly, original requirement. So, the computer programs must meet the originality requirement to qualify the copyright protection by ensuring that they embody minimum level of creativity and unique expression. They have exclusive rights. So copyright law grants the creator exclusive rights to reproduce, distribute, or to adapt their software by preventing the unauthorized copying or distribution by the others. So this includes rights against both the literal copyright and unauthorized derivative works also. The comprehensive protection. In addition to software code, copyright protection can cover related elements such as the user interfaces, graphics, and sound tracks. So this all embedded in the software. So contributing to a comprehensive protection of the software product, it as a whole is very necessary. So what are the international treaties on software copyright? So basically, with regarding to copyright, there is the three conventions are there. One is Berne Convention, later WIPO Convention, and last one is TRIPS Convention. So TRIPS Agreement, copyright protection under Article 10 Clause 1 of the TRIPS Agreement. It said the computer programs should be protected as literary works by the same level of protection is granted to the software also. So this agreement obligated the member countries to provide copyright protection to computer programs in both source and object code formats also. And through the WIPO convention, under Article 4 of this convention, it's slightly different in wording. What it said is, they should be treated as literary works under copyright law. But this treaty emphasized the need for member states to ensure that copyright law adequately protects the rights of the software creators against the unauthorized copying and distribution. So the question arised here is the authorship issues in works used or made or generated works of the computer. When a computer the data that result from such processing may be well protected as a literary and artistic work, but it gives some questions. Number one is, if the information processed by the computer is expressed in a word protected by copyright, then is the use of such work by the computer under the control of the copyright owner of the work? The second one is, where a computer has been used to process information in such a way as to produce a work of a kind normally protected by the copyright, then who is to be regarded as the author? So, copyright owner of the resulting literary work or musical work. So, in both internationally and nationally, there has been a very large measure of agreement on the answers, and the general consensus is recorded in a report called the Report on Second Committee of Governmental Experts on Copyright Problems. So, this convention, the major conclusions with regarding to this convention in 1982, it was held in Paris. The first recommendation is the input of a protected work into a computer system includes the reproduction of the work on a machine readable material support and also the fixation of the work in the memory of the computer system. So both these acts, the reproduction and fixation, are governed by the Article 9 Clause 1 of the Berne Convention. And the second recommendation is the output of the protected work from a computer system should be protected under the copyright law, irrespective of the form of the output. For example, as a hard copy printout, a fixation in machine readable form, a transmission from the database of one system in the memory of another system, or by making the work available to the public by audio or visual images presented on the screen. The third recommendation, in amending or modifying the national legislation to take account of computer use of protected works. Care should be taken to ensure that the author's moral rights should continue to be exercisable in relation to the computer use. So, the exemptions and limitations on the copyright owner's rights of the control, which the computer technology might render desirable, it do not exceed the limits on the exemptions permitted by the convention. The fourth recommendation is the non-voluntary licenses in relation to the computer use of protected works should only be adopted when voluntary licensing is impracticable and should in any case be in accordance with the convention principle. So many countries, the existing law appears to be regarded as the implementing these general conclusions, but in some countries there have been specified amendments also done to the copyright law. So the general view which emerged from these studies that there is no matter how sophisticated a computer may be, but it is only a tool, and the author of a work produced by the aid of the computer is the person who conceived the product and who gave the program and the technician the instructions necessary to produce it. So neither the program who designed the program needed to operate the computer for the purpose of producing the work, nor the technician who operated the computer when carrying out the task would be regarded as the author or a joint author. However, where the work of the program amounted to collaboration with the originating creative person to such an extent that the programmer contributed creativity in setting the form of the final product, he might be regarded as the co-author. So, what is the patenting of computer system, computing software? So, the computer software, computers, these are the powerful run complex software. The software related inventions initially it received a chilly reception at the patent offices around the world when the patent applications directed to computer related inventions were first filed. But there were the few that by statute patents can only be granted to process, machines, articles of manufacture, and composition of matter. So, in particular, patents cannot be granted to scientific truths or mathematical expressions. So, the idea that the computer program solved the mathematical problems and are thus more equations has long held them to non-patentable. So, the criteria for patenting software has evolved, but it remains critical that a software invention demonstrates novelty, inventive steps, and industrial application. So, patent application must clearly articulate the technical contribution and the benefits of the software to meet this criteria. So, different countries has different procedure for the granting patents. For example, in the USA, In the case of 1981, Diamond versus There, the US Supreme Court ordered the US Patent Office to grant a patent on an invention even though a substantial part of the invention consists of a computer program. That this used well-known formulae for calculating the time when rubber was cured and the mold could be opened. So the statement of the Supreme Court in this case is the invention was not merely a mathematical algorithm, but it is a process for molding rubber with which was thereafter patentable. So after that, US Patent Office developed guidelines and began issuing patents that were explicitly software related. And in the case of European Patent Convention, so this European Patent Convention, this excludes discoveries, scientific theories and mathematical methods, schemes, rules, and methods for uh, performing mental acts, playing games or doing business. So these are all excludes from the patentability. But in 1986, again, the European Union Court decides the European Patent Office, the European Patent Convention in a new inconsistent way in response to demand from industry. So the now they paved the way to unlimited patentability to the area relating with technology also. So after this 1986, the European Patent Office started granting patents that direct into the computer programs. Even in Japan also, apart from the universal requirements for novelty and non-obviousness, patent can be granted on anything that is a creation of technical ideas utilizing natural laws. So, the software and business methods are concerned. This means the patents can be granted where an invention is achieved through the concrete use of hardware resources. So, the Japanese implement guidelines for inventions clearly states that both process and product claims are acceptable for software related invention. So with regarding to process, where a software related invention is expressed in a sequence of process or operations connected in time series, so the invention can be defined as a process invention by specifying the procedure. Or if it is a product patent, where a software related invention is expressed as one or more functions performed by the invention. So in that case, the invention can be defined as a product invention by specifying the functions with regarding to computer readable storage medium, having a program recorded in the computer readable storage medium having structured data. So in the case of China, Chinese patent office rejects software related application on the ground that they are the rules and methods for mental activities that are not patentable as prescribed by the patent law. But any claim with computer program or medium containing computer instructions, their subject matter will be rejected. But in India, the Indian Parliament passed a patent amendment bill in 2005. So this patent amendment bill under section 3 clause K, they amended this section 3 clause K of previously existing patent act. They added computer program is not patentable. So the old section 3K, it reads with computer program per se, other than its technical application to industry, are combined with hardware. But in 2005 amendment, computer software implemented inventions having a technical effect outside the computer was patentable, but the present situation is quite fluid. So what are the effective drafting for software patent? So the success of patent application of the software inventions relied on the meticulous drafting of the claims and specifications. So the clear articulation of technical contributions, that is the three requirements to get the patentability, that is inventive step, novelty, industrial relation. You have to clearly articulate, and the practical application is essential to meet patentability criteria. Additionally, by utilizing diverse claim formats and anticipating possible rejections also gives strength to the application. So, by engaging with both technical and legal perspectives during the drafting process, it ensures the comprehensive protection and increases the likelihood of approval. So, claiming strategies for software patents. What strategies may be there to claim the strategies? Common claimings. So, varying standards across the regions. So, different national patent offices impose varying standards for the patentability of computer implemented inventions. So, in the US, a broad approach permits patents on business methods and software as long as they produce a useful concrete result. So in contrast, the European Patent Office, it requires a technical contribution that is not abstract. It emphasizing the need for a technical effect. So the Japanese Patent Office, it allows patents when the invention involves concrete use of hardware resources, making it less stringent than the European Patent Office, but still more so that US standards. The second one is importance of diverse claiming strategies. So you should include as much as diversity in the claims as possible. This it helps in the every scope of the software claims among the narrow, medium, and broad scope. So by drafting claims of at least two different scopes of protection, the patent claim will be harder to invalidate as a whole, while infringement of the claim will be maximized. So the strategy to draft claim with the possible combination and subcombinations of the invention may help the patent owner by providing more complete relief, targeting at the most significant infringing activity. So to maximize patent protection, it is crucial to adopt multi-claiming strategies. So the multi-claiming strategies will cover broad and narrow interpretations. For instance, including system claims, process claims, and product claims can help protection different aspects for innovation. And regional claiming strategies. So basically, different countries have different regions, established as different regions. For example, European region, African region, in the case of the patentability. So in Europe, claiming strategies must emphasize the technical contribution of the invention. So the claims should highlight how the software or the process improves technological functions like efficiency or memory use. So in that case, the US, it claims can be broader, focusing on any useful application of the software. But at the same time, Japan requires a clear practical application, but offers a more lenient approach compared to the Europe by allowing claims that utilize hardware resources effectively. So what is the growing landscape of software patents? So the popularity of software patents has surged, leading to a notable trend among large software companies to engage in cross-licensing agreements. So these agreements are strategically used to circumvent costly litigation by enabling firms to share technology by protecting their intellectual property rights. Due to this, software patenting not only innovates so what are the comprehensive protection strategies for software is, so the software protection, it encompasses various legal frameworks, it including copyright, patent, and trade secret laws also. So what are the practical effects of the software patents? So the patent software has become more popular. So due to this, it is difficult to quantify. But as an indication, in 2005, Microsoft alone has 6,130 issued patents, which are presumed mainly software patents only. But at the same time, IBM received 3,415 patents in 2003. But many of them are not related to the software. So most large software companies, they have cross-licensing agreements in which each agrees not to sue the other over patent infringement. For example, Microsoft has agreements with IBM, Sun Microsystem, SAP, Hewlett Packard, Siemens, Cisco, and recently Autodesk also. So this, interestingly, Microsoft agreed to share with Sun even though they are direct competitors. And with the Autodesk, even though they have far fewer patents than Microsoft, it appears that large companies would prefer to avoid expensive and uncertain litigation rather than assert their own intellectual property rights. So some large companies, aggressive licensing program, it gives 2 billion US dollars a few years later. Licenses are often charged as a cost per unit sold, or at a few percent of gross sales. So this license tax can become a major burden if several different organizations are claiming patent violations. So in practice, inventive step requires for new software patents appear to be quite low, but in particularly many inventions appear to be nothing more than that applying well known business practices over the web. The quality of assessment also seems to be quite low, with well known prior art often ignored. So, for example, Microsoft file allocation table, patent licensing, it has resulted in some software patents they being rejected and re-examined also. In practice, the software engineers rarely search patent databases and application looking for new inventions that could benefit their projects because of lack of inventive step in many software, or due to the obscure languages which the software patents are described, or the risk of being accepted for triple damage for knowingly. So these are the looking thoroughly. So I hope with this we are concluding this new areas in the patent, where the expansion of the patent will be covered. So with this, today we are discussing both topics under enforcement of intellectual property rights in the international level through the especially the TRIPS agreement, and later patent in new areas, in the especially the biotechnology areas, the genetically resources plant and animal animal varieties in the food and agriculture sector, with regarding to some conventions of that convention of biological diversity, international undertaking, and international treaty also. And lastly, we are discussing with the protection of computer software. So I hope with this, the international framework is concluded. So if you have any doubt, then you can ask in the chat box. Otherwise, shall we wind up the class? Okay then, thank you for cooperating to smooth conduct of the classes. Thank you.